Okay, welcome to tonight's webinar. It is on the basics of liability and protection, which is a very sort of straightforward basics class. And then next month's webinar on May 7th, I think the date is, but the first Wednesday in May, it'll be the advanced asset protection class that I actually did last Saturday. And so that is more, this is the basics and that is more advanced. So you can always review this online after it's put up on the website and review the basics of liability and protection. And then we will go through uh, the more advanced stuff next month. So look forward to that. So anyways, tonight we're gonna start talking about liability and what liability is, and then the basics of how to protect from it. Um, so liability. Let's need to just make sure this is, there we go. Liability, here's just a very basic definition. This comes probably right out of some law dictionary somewhere. Liability, it's a financial obligation which may be satisfied from the responsible party's assets. Now there's three sections that are underlined there. The first is a financial obligation. The next, and we'll talk about each one of these in detail, but that's pretty much something has happened in which somebody is damaged, and that damage can be repaired by money. Generally, in the law, we don't put people in jail for hurting other people unless there's some sort of criminal statute violated. Generally, we like to reduce everything down to money and make money change hands for these kinds of things. And then when there is a financial obligation, they need to recover that money from the responsible party. So who's responsible is a big deal in this, and that's why that is underlined. And once they determine who that responsible party is, they can go after any of that party's assets in order to satisfy the judgment. So that's what liability is. It's a financial obligation which may be satisfied from the responsible party's assets. So let's take a look at each one of those a little bit more closely. A financial obligation. This is a debt or a damage. Debt's pretty easy. You can think of this, any contractual debt you might have. Be it a mortgage. If you take out a mortgage on a home, that is a contractual obligation to make payments or to pay somebody back. That is a debt that you owe. And a damage is any sort of injury that you may cause on somebody else. This could be a traffic accident where you're driving down the car and you hit somebody and you dent their car or hurt somebody. That is a damage. It could also be your dog. If your dog goes out and bites somebody, then that is damage and you are responsible for your dog. It could be a tree in your yard. If the wind blows and knocks off a branch and that branch falls on the roof of somebody else's house, then that is also a damage caused. So financial obligation is any kind of debt that you may owe or damage that you might cause. Who is the responsible party? This is where we'll talk mostly about. It's either personal or professional. So let's look at each one of those. Personal liability, and I use this a lot, both when I'm talking about liability and protection and when I'm talking about asset protection, when I'm talking about corporate protections. Understanding the difference between personal liability and professional liability is very, very important. And so personal liability is something that originates with you, something that ties to you as an individual, you as a human, something caused by you acting in your own individual capacity. Personal guarantees on promissory notes, mortgages where you're the borrower, car accidents, a dog. If it's your dog and you're the owner of that dog, then you are personally liable. And so if something happens where it's you as an individual causing that debt or causing that damage, then you personally are the responsible party. And if you are the responsible party, anything you own can be used to satisfy that judgment. Because if you go back to our definition of liability, it is a debt or a damage uh, that can be satisfied by the responsible party's assets. And so personal liability is actually a bigger deal than professional liability. Professional liability will be contained within your entity or the business that you work in, whereas personal liability can attach to your personal assets, your personal home, savings accounts, stock options, and it can attach to any business holdings that you might have. So it can attach your ownership in LLCs or corporations, etc. So that's personal liability, and it's the one that we really want to protect ourselves from the most because it actually has the most to lose. Professional liability. This is liability that originates with what you do as within your profession or within your business. So if you created a medical device and you sold that medical device, if that medical device caused damage to somebody, then your professional entity is responsible. If you are a landlord and your tenants are injured, if you run that landlord through a business, then the business is responsible for that tenant injury. Business loans, and this kind of becomes a big deal with hard money lenders and borrowers. So when you borrow money, you want to borrow that money within your LLC because then it's a business loan and not a personal loan. Many hard money lenders may try and make you sign a personal guarantee, and what they're doing on that is they're making you also personally liable for that debt as well as professionally liable. And by doing that, they've got more assets to go after, right? That's what lenders want, banks want. They want to be able to get their money back if necessary. And so they want to be able to attach the most assets that they can. But if you're the borrower, you want to borrow strictly within in a professional manner and not personally, because then the responsible party is your business and not you. And remember, I go back to the definition again, that a liability is a debt or a damage, a financial obligation that can be satisfied by the responsible party's assets. So if the responsible party is your business, then only your business assets are at risk. Your personal assets or other businesses that you might own are protected. So professional liability is kind of a containment. And you want to do as much as you can within this business entity so that you can contain all that liability from other assets that you might have. Now, the problem that most small business owners, real estate investors, etc., run into is that this professional liability can very quickly become personal liability. So it can kind of jump the fences here. If you are your business, and what do I mean by if you are your business? What that means is you do not set up a business entity and you do everything in your personal name. So you may be a landlord of rental properties and it looks like a business. I mean, landlording is a business. You make money from it, you have costs and expenses with it. But just because it looks like a business, if you don't set up the proper entity, then you are your business, and anything that happens within that business of landlording is actually going to attach to you personally, and it's going to be personal liability. Or if you set up an entity and you don't maintain it properly, this is called piercing the corporate veil. This is when you have an entity set up like an LLC or a corporation, and you're running your business. But if you don't maintain it properly, you don't sign your contracts correctly, you don't fund it properly, you don't transfer assets to it properly, if you commingle funds or don't do your bookkeeping correctly, these are reasons that the court can look at and say, you know what, yes, this person set up a business entity, but they didn't really treat it like a separate entity. And if the person didn't treat this company like a separate thing, then we're not going to take it as a separate thing either. And they're going to say, it really wasn't the business running the show. It was really you as the individual. And they're going to pierce through that corporate veil protection and make you personally liable. So in those situations, even though you might think you're containing this liability within your business, um, that business liability can quickly become personal liability. And again, what is our goal? Our goal is to really first contain as much as we can within the business, and then do what we can to shield that business from personal liability. And we'll talk a little bit about that later. Okay, the last part of our definition, assets. An asset is anything of value owned by or under the control of the responsible party. Now, I put this definition up here for a reason. There's very often the saying to protect your assets, you want to control everything and own nothing. Now, that's actually some good advice. Because ownership, if you own it, then obviously it's an asset, and the court can attach it in a judgment. But the courts can also attach things that are under your control. For example, a family trust. Family trusts really don't provide any protection because you as an individual still control the assets that are inside that trust. So there are ways of controlling things and not owning it that can lead to some asset protection, but courts can look at anything that is owned by you, so it's titled in your name, whether it's a savings account, mutual funds, other LLCs, rental properties, personal homes. These are all owned by you, or things that you may have a considerable degree of control over, such as a trust. But it is things that of the responsible party. So again, remember the entire definition that liability is a financial obligation, which is a debt or damage, that can be satisfied by the responsible party's assets. Okay, courts cannot go after somebody who is not the responsible party. Take, for example, a husband and wife. If a husband gets into a car accident, if there are assets that the wife owns, the court cannot go after those assets because they are owned by the wife, not by the husband, and the husband is the responsible party. So part of asset protection can be putting assets into somebody's name who runs less of a liability. Okay, so there's our definition of liability. And the more you kind of understand that, the more everything else will make sense. Okay, protecting your assets. What do we do to sort of protect things? Well, we're going to talk about two types of protection that are important. And before we talk about the two of them, here are questions. I very often start off these classes with the saying that there's no such thing as a silver bullet. There's no such thing as bulletproof. There's no such thing as ironclad. And there's no such thing as perfect protection. I go to a lot of seminars and webinars and asset protection classes, and very often you'll hear even attorneys say things like, this is the bulletproof method. And in fact, nothing really is bulletproof. Things can become bulletproof, and there are ways that things can be perfectly protected. But you kind of got to get there. It's not necessarily a guarantee, and that there are ways to do that. So our goal really in protecting assets is education, teaching you about liability, teaching you about protection, and teaching you how the best ways are to protect things and the things that you can do. Asset protection really isn't a static event. It's not something that you do once or do one time or do with a lawyer in a lawyer's office and then forget it for the rest of the year or the rest of the time that you own that asset. Asset protection really is a long-term, constant endeavor to keep and maintain that protection. How you protect it and the vehicles that you use to protect it depend on a number of things, these 6 questions. The first question is, what are you protecting? For example, protecting a rental property in Utah will be different than protecting a rental property that you might own in Nevada, because that's out of state from where you're living. You also might protect a rental property differently than you protect your personal home. You might protect your personal home differently than you protect stocks or mutual funds that you might own. And you'll probably protect those stocks and mutual funds differently than you might protect cash. If you've got lots and lots of cash that you keep in bank accounts, you'll protect that differently. So different things require different protection tools. The second question, who are you protecting it from? It's often a joke. Are you protecting it from a partner that you might be working with? Are you protecting it from lawsuits within the business, like from a tenant? Are you protecting it from judgments from personal liability, like a car accident you might get into? Are you protecting it from an ex-wife or from a current wife, spouse? So who you're protecting it from matters in how you are going to protect it in the vehicles that you're going to use. Third, where is the asset located? Is it property or is it intangible? Real estate's very obvious where it's located. It's located on the land that it sits on, and that land is going to be within the geographical boundaries of a certain state. So if you own property in Utah, you know that it's located in Utah. If you own property in Arizona, you know it's located in Arizona. That asset could also be located in your house. It could be in a vault that you keep in your basement. You might keep that asset between the mattresses in your bed. That asset might be located in a savings deposit account at a bank. It might be located in as a stock option, with the company that you bought the stock from. So again, where the asset is located matters when deciding how to protect it. When are you trying to protect it? This is a big question, and it's very easily answered. You always want to protect it long, long, long before you run into trouble. Doing things early is the best advice I can give. The longer assets sit in whatever protective tool you use, the longer it sits there, the more protected it is. If you're trying to protect something after you've run into trouble, well, there's probably not a lot I can do. You're probably toast, and you're probably going to have to sell that asset to pay the judgment. You probably already lost it. And in fact, even taking that asset and moving it into a protective vehicle, maybe an irrevocable trust, an LLC, corporation, family limited partnership. If you transfer that asset into one of those vehicles, within a short time period before you run into trouble, the courts can actually make you take that asset back out because they'll actually call it a possible fraudulent transfer. And you'll have to prove that you had good reasons for moving it into this asset protection vehicle right before you were sued. So again, when are you trying to protect it? You never know when liability is going to arise. So the earlier you protect things, the better. Why are you protecting it? There's a lot of reasons why you might protect something, and this kind of plays into estate planning. Sometimes people want to protect an asset for the short term because maybe they're flipping a house or they're starting a business they're going to sell off. Things that they want to keep more liquid. They want to be able to use the proceeds from, but they want to make sure that it's protected in the short term because they need to keep using it or turning it over. Other people may have assets that they want to protect for a very, very long time for estate planning purposes. They want to make sure that asset is around to leave to their children when they die, or leave to charity or something. So your reasons for protecting that asset come down to, what do you want to use that asset for? What are you using it for? Are you using it to derive income off of so that you can live today? Do you want to hold it for a long term so that you have income at retirement? Do you want to hold it so that you can leave it to children? So these are the questions you need to ask yourself as to why you are protecting it. Then the final question is, how do you want to protect it? This will actually be answered after you answer the first 5 questions. When you kind of know all of those things, you need to choose a vehicle to protect it. There are numerous vehicles, family limited partnerships, multi-member LLCs, single-member LLCs, generic limited partnerships, trusts, both land trusts, family trusts, and even irrevocable trusts. There's things you can do offshore. You can actually set up some offshore trusts and try and put money in foreign countries. I don't necessarily do that, but there are ways to do that as well. So there's a lot of vehicles out there to protect that asset, and the choice really comes down to the answers to the previous 5 questions. Okay, so those are the questions you need to ask yourself with the assets that you're trying to protect. Here's the biggest note that I can probably say right now is that businesses are protected by business entities. There's lots of kinds of assets, right? You might have cash accounts, you might have family jewelry, you have your personal residence, you have stocks, mutual funds, insurance, annuities, lots of things that you might own of value. And there's ways to protect those things. But right now we're going to talk about your business. This is the business that you might be engaged in. It might be producing and selling t-shirts. It might be creating a medical device. It might be flipping properties. It might be holding real estate long term. These are all businesses that we are engaged in. And businesses are always protected by business entities. So for these things, the first step in asset protection really is setting up a business entity because it provides a great deal of protection for both professional and personal liability. So let's move on with sort of how businesses are protected and even assets are protected by business entities. So this is just a diagram. At the bottom in red, that's liability. That's something bad. That's the car accident. That's the debt, a mortgage that you owe, or your business owes, I should say. So that's the bad thing that's trying to get at your assets. Now, professional liability is self-contained within your business entity. Like we said before, if you have an entity set up and that entity is run correctly. So the way we protect these business assets is through a maintained, properly set up business entity that provides protection. Professional insurance, we always recommend insurances, and that will help protect those business assets from professional liability. You'll notice, though, that the personal assets on top aren't touched, right? Because that business entity kind of stops that professional liability from getting any higher. It can't get through the business and attach those personal assets. That's called the corporate veil protection. That corporate veil protection maintains everything within the business. And if the judgment or the damage or the debt is greater than your professional insurance, those business assets might be sold to satisfy the judgment, but you're still self-containing everything within that business, and your personal assets will be protected. And that's what we call the corporate veil protection. It protects your personal assets from professional liability. Now, here's the other way around. This is personal liability. So this is when you might be in a car accident or a personal debt or something like that, and you're being sued as an individual. and they're going to go after anything you own. And what the court is looking at is like, wow, this person owns a business, and this business has a lot of assets. And if you're a t-shirt printer, maybe the company owns printing presses and computers and inventory that's worth hundreds of thousands of dollars. If this business is a landlord who owns rental properties, they're seeing lots of real estate, and maybe there's hundreds of thousands of dollars in real estate. Now, all of these things are business assets. They're owned by the company, they're used by the company, they're part of the company's business. So the question becomes, can the court come in and force you to sell off these business assets to satisfy the judgment against you? Well, the answer is yes and no. And it depends on how many people are involved in the business. We have something called charging order protection. This is a protection of business assets that derives from partnership law. Now, partnerships must, by definition, have at least two people involved, right? You can't be partners with yourself. So if you've got two people involved, you're in a partnership. And the way this law works, it was kind of derived by the courts. And courts kind of looked at this and said, okay, you have partner A and partner B. Partner A got into a car accident and killed somebody. And the family of that deceased person is suing partner A for $10 million. Partner A is a 50-50 owner in this business with partner B. And this business has $10 million in assets. So of course, the family wants to go after that $10 million in assets so that they can get paid on this judgment. And so the court looks at that and says, no, should we force this business to liquidate its assets, sell everything off to pay partner A's debt, his damage? Well, what would that do? That's going to hurt partner B. Partner B didn't do anything wrong. He didn't kill anybody. He wasn't out driving recklessly. And it's not fair to partner B to lose this business and to lose all of those assets. Yes, partner B would get his 50% share because the court couldn't go after more than partner A owned, but still they'd have to sell everything off. The business would shut down and they would lose all future value, and that would hurt partner B. So what the court says is, we're not going to force the business to sell off the assets. Those assets are protected, and we're going to leave them in the business so that partner B isn't harmed. This is called a charging order protection. This charging order says that the creditors, or the plaintiffs in this case, the family who lost somebody in this car accident, they get a charging order against partner A's receipts from this business. So anytime this business allocates a distribution and allocates profits to the partners, partner B gets his 50% of the profits that month, but partner A's profits would have to go to the family of the deceased, because they get what partner A would have gotten. The family of the deceased, they don't become members or partners in this company, so they're not owners of it. They're not managers of it. They get no voting rights in it. The only thing they get is whatever partner A would have gotten if things are given out. And so what happens in this situation is the family of this deceased person, or let's use a better example, let's just call it creditors. It's kind of sad to think that a family who lost somebody is not going to get paid. So we'll just say that partner A had a $10 million debt on gambling, that he went to Vegas and lost, and now he owes a loan shark $10 million. That loan shark only gets a charging order for whatever receipts and money partner A would have gotten out of here. But what the partners can do, what partner B can do, is make a decision not to distribute any funds. And so they're going to leave the money in the company and not make distributions. That way, this loan shark who now would get anything partner A would get, gets absolutely nothing because nothing's being distributed out. And the loan shark can't, he has no managerial rights or voting rights, so he can't force the company to make a distribution. So he sits around year after year after year waiting to get paid from this company that's not making payments. The other thing that happens is the tax liability. Remember that in a partnership, the partners have to pay taxes on their share of the income through what's called a K-1 statement, and many of you may understand that. Now remember, this loan shark steps into the shoes of partner A and gets whatever partner A would have gotten. Not only does that include distributions, but it also includes the K-1 statement. So if the company made profits of $100,000 in a year, there's going to be K-1 statements issued to each partner. Partner B is going to have to take his K-1 showing $50,000 in income, but so is the loan shark, because the loan shark now is responsible for paying taxes on partner A's share of the profits, even when those profits aren't distributed out. So this charging order protection really becomes valuable, and it really kind of prevents people from even going down the road in the first place of getting one, because what could happen is they could end up with a tax liability year after year after year and paying tax on something and never getting a distribution. And this could go on for decades. So a lot of when people who are owed money are looking at this, they're much less likely to even bother in the first place because they may never get paid. But even if they do want to go after it, that business asset is still protected. And this charging order protection is really, really great to protect that business asset. But again, it derives from partnership law. And so you must have a partner. This charging order protection does not come from single member LLCs, things you own in just your personal name. It must be a multi-member LLC or a partnership where there's actually somebody else involved. Because the point is to protect the innocent partner. So as long as you've got an innocent party involved in the company, that business asset is protected. Okay. So how do you protect your business? These are the sort of 6 steps in tonight's program that we're going to talk about in making sure that this business, these business assets are protected, and your personal assets are protected. The first thing you want to do is set up the proper business entity, and you'll need to decide what kind of entity you're going to set up. You might set up a corporation, you might set up an LLC, you might set up a partnership. The corporation and the LLC both come with that corporate veil protection to protect your personal assets. In a partnership, there are limited partners and general partners. You get that corporate veil protection for the limited partners, so that's a good thing. Limited partners kind of have that same corporate veil protection, protecting their personal assets from things that the partnership might do. The problem is with a partnership, somebody has to be the general partner, and the general partner is liable for everything that partnership does. So very often when people set up a partnership to run a business, they'll make the general partner a corporation, because that corporation then gets corporate veil protection that way. You very rarely will want an actual human being individual to be that general partner. So the first question is, what entity do you use to set up? And if you're by yourself, and you just think, okay, I want to set up an LLC, but it's just me. I don't want to partner with anybody. I don't have a spouse. I don't have children. Do I have to set up a single member LLC and not get that charging order protection? Well, there are ways around that too. We can actually create a multi-member LLC where you're a part owner, and we make a corporation that you own a part owner. So that LLC technically has multiple members, and a corporation is a distinct entity under the law. It's created by law as a separate and distinct individual. So there are ways that even single people can get that charging order protection. The next thing is you need to properly organize that company. Uh, there are decisions that you make when setting up an LLC or corporation or even partnership. Who are the members? Who are the partners? Are you going to be member managed or manager managed? What's the purpose statement? And these sort of questions. What percentage ownership do we allocate? And so you need to decide how you're properly going to set it up. The third thing is you need proper documentation. Just filing articles with the state or filing the partnership papers with the state really doesn't provide any liability protection. It gives you a name. With that name, you can get an EIN and file your taxes, but it doesn't give you actually any protection. That protection comes in the operating agreement for an LLC or the bylaws for a corporation or the partnership agreement for the partnership. And those are the documents, you can kind of think of those as the constitutions of the business. And that tells you, it provides the liability protection and it tells you how to run the business. Proper funding. This is a big topic, and I do other webinars on sort of more of this. But proper funding means that you have enough money in the account to cover its expenses, that you transfer title to all the assets into the name of the company, and make sure that the company has the ownership and the documentation, the paperwork showing all of that, so that it's properly funded. And then once all those assets are transferred into the name of the entity, proper maintenance. This includes how you contract, how you represent yourself publicly, how you sign your contracts, how much money you keep in the account, how you do your bookkeeping, how you the meetings that you hold, the votes that you take, etc. Because all of these things, if not done properly, can combine to allow the court to pierce that corporate veil and lose the protection, and even the charging order protection for that matter. They can decide to negate that as well. So maintenance is very important, which is why anytime you see seminars or lecturers telling here's a set of legal documents and this is all that you need for protection, that's really just kind of the beginning steps. And yes, you need those documents and you need to set them up and use them, but then over time you have to maintain it. I always teach that asset protection doesn't come in your lawyer's office, it comes in a court of law. It comes from a judge or possibly a jury that determines whether or not you get these protections or not. So you want to be able to go into court with the most evidence that you can. You want the best choice of entity, you want it properly organized, you want all the proper documentation, you want it properly funded, and you want all the documents of maintenance that you've been collecting over the years. And the longer this entity stays around, the longer you maintain it correctly, the bigger pile of evidence you are creating. And it's that big pile of evidence that's going to get you the protection in court. If you can't go into court with any evidence, you can't prove that this company deserves that protection. Corporate counsel, that's me. That's part of my job, is helping my clients make these decisions about the proper entity choice, the proper organization, help them with the documentation and funding, and then help them maintain it so that they can get the best asset protection that they can. Okay, most of you know this. This is just the end of the PowerPoint. What do I do? I can help ensure that you have the proper business legal structure for your business. I'm not, as you know, an online form generator where you have to make all the decisions. You can actually call me, talk to me, ask me questions. I ask you questions, and together we determine the best structure for your business. I help you feel comfortable with all your legal dealings with others. That's contracting and relationships. I help you maintain your company with meetings and maintenance. And hopefully you become successful in real estate investing or in any other small business endeavor you might be engaged in. That's my job, is to help you become successful. So that is pretty much what we've got for tonight. And now I will